This video is called The 3 Legal Traps Lawyers Use to Seize Your Wealth and How to Block Them. And in the next 60 seconds, I'm going to show you the exact legal moment when a lawsuit stops being paperwork and becomes a financial chokehold, and the one move that makes that chokehold fail. And here's the problem. If you're a business owner, a real estate investor, you've built a net worth north of $1 million, you don't just have assets, you have targets. And most people lose not because they're wrong, but because the other side trapped their cash flow, boxed in their options, and forced a settlement they never wanted. So here's the promise. By the end of this video, you'll know the 3 traps plaintiffs' attorneys use most: the freeze, the pierce, and the clawback, and you'll have the specific legal counter move for each one so you can stay calm when the other side runs out of leverage. So here's the path. First, I'll expose how they trap you. Then we'll block each trap with structure, timing, and documentation. And finally, I'll show you the nuclear option used at the high net worth level, a properly built Cook Islands trust with a Cook Islands LLC inside of it, where you control the LLC when waters are calm and our licensed, bonded, trusted company law firm steps in only if a lawsuit strikes. Okay, now here's the 60-second payoff I promised. The chokehold usually begins the moment the other side gets something on record that locks your options, a lis pendens. That poisons a property sale or refinance, a court order that restricts movement, or even a bank compliance hold that makes your money feel frozen before you've lost anything. So this is the leverage play. Once you understand it, you can block it. So let's get to work. Chapter 1, lawsuits aren't about truth, they're about leverage. Hi, I'm Kevin with the Lawyers Limited Law Firm and Asset Protection Planners. I've been in asset protection for 35 years, and I've been setting up Cook Islands Trusts for 30 years. Over that time, we've set up, I believe, more Cook Islands Trusts than any firm in the world. Not as a brag, but as a reality check. We've seen how sophisticated plaintiffs' attorneys actually play the game. Now, here's the mindset shift that protects your money. A lawsuit is rarely a straight line to justice. It's a pressure campaign. Plaintiffs' counsel wants one thing: a settlement that feels expensive to you and profitable to them. And the way they get it is not by always winning at trial. Many cases don't even reach a verdict. They get it by turning your life into a series of impossible choices. Spend a fortune defending yourself, or write a check to make the pain stop. So they run 3 legal plays that creates the pain. And before we hit trap number 1, a quick note: none of this is about illegal hiding. It's about lawful planning, structuring ownership, reducing leverage, and limiting visibility. Same reason you wear a seatbelt. You're not planning a crash. You're acknowledging reality. Okay, here's a cliffhanger for you. In a few minutes, I'll show you the single document that currently hands plaintiffs' lawyers a full map of your wealth, even if your deeds and LLC look clean. Most high earners have signed it. Okay, chapter 2, trap number 1. The freeze, prejudgment attachment, lis pendens, and account pressure. Let's start with the trap that catches smart people off guard because it feels like cheating. Most defendants believe they can't touch my assets until they win. In many cases, that's simply not how it works. Lawyers have tools that can freeze, fence, or poison your assets early. Prejudgment attachment on certain cases and jurisdictions, temporary restraining orders and injunctions, subpoenas that create chaos, and in real estate disputes, lis pendens. In fact, we had one client who called and called and called back 11 times with questions and always wanted to procrastinate. And all of a sudden they called us and said, "What's a lis pendens?" And we said, "Well, we told you this could happen. They could freeze your assets mid-lawsuit," and that's exactly what happened. At that point, there's nothing we could do. So planning early and acting early is really the key. A lis pendens is Latin for lawsuit pending or lien pending. And what it really means is this property is now radioactive. You can't sell it, refinance it, your property is frozen until the pit bull is off your neck, the lawsuit in this case. Here's a composite case study. David owns a commercial building worth $5 million. There's $2.2 million in debt. So he has roughly $2.8 million in equity. A former partner sues and alleges fraud. The plaintiff's attorney records a lis pendens. Now, David hasn't lost anything in court yet, but watch what happens. No buyer wants the building. No lender wants to refinance. His bank gets nervous. His leverage evaporates. Now the plaintiff's attorney offers a settlement, pay $450,000, and will release the lis pendens. That's not justice. That's a toll booth. So how do we block the freeze? We'll call this block for the freeze, reduce free equity, and reduce touch points. There are two legal realities that drive this. Number one, lawyers chase what looks collectible. Number two, judges are less likely to grant extreme remedies when the asset doesn't look like a jackpot. In practice, this means we focus on equity management for exposed real estate, cash flow separation, and ownership architecture that doesn't leave a single obvious grab handle. Okay, real estate, equity stripping done correctly. Here's a solution for you. If a property shows massive free equity on public record, it's bait. If it shows low free equity because legitimate liens exist, the incentive drops. This can include properly documented, properly recorded debt, sometimes from institutional lenders, sometimes through structured planning where the equity is lawfully encumbered. The point isn't to fake debt. The point is to stop advertising a clean payday. Cash, we separate operating cash from wealth storage. If your main operating account holds big reserves, you've concentrated your most touchable asset in the most visible place. Separate payroll and operating expenses, tax reserves, and long-term savings. So when a lawsuit hits, you don't want your business breathing through a straw. Here's a cliffhanger for you. In about a minute, I'm going to show you the frozen account moment most people accidentally create without any court order at all. And the one sentence that your attorney should never let you say to a bank. Okay, the frozen account moment without a judge. Now, banks are risk averse if they receive subpoenas, allegations of fraud, or conflicting claims over an account. They may restrict activity while they review. Sometimes it is not a thing frozen by the court, it is paused for compliance. The sentence that triggers the problem is, there's a lawsuit and I need to move money fast. That sounds like I'm about to do something that will later be questioned. Instead, the correct approach is calm and ordinary. We're managing normal business operations while counsel handles a dispute. You're not lying. You're just not panicking on the record. And now, trap number 2. Chapter 3, trap number 2, the piercing the corporate veil and reverse piercing. So this is the trap that destroys the DIY crowd. Somebody will tell you, just put it in an LLC. Now, an LLC is helpful, but it's not a force field. A domestic LLC is a contract with your state. If you treat the LLC like your personal wallet, plaintiff's counsel tries to convince a judge the LLC is your alter ego. That's veil piercing. How they do it? Commingling funds. That is paying your personal electrical bill with your company bank account. No records, sloppy bookkeeping, no documented loans or distributions, undercapitalization, signing personally when you should sign as manager, treating the entity like it exists only when convenient. Here's a composite case study. Melissa owns a medical practice inside of an LLC. She's successful, busy, and she uses the business card for life, groceries, vacations, school tuition. An unemployment claim hits. The plaintiff's lawyer doesn't just sue the practice, they sue the alter ego, arguing the LLC is a costume. Now, the fight is no longer, did the claim have merit? The fight is everything Melissa owns reachable? And it gets worse. Reverse veil piercing. Reverse veil piercing is where you get sued personally, car accident, personal guarantee, unrelated claim, and they try to reach the business assets to satisfy the personal liability. Depending on your state, single-member LLCs can be vulnerable. Some states handle charging orders well, and others are less protective in practice than people assume. So how do we block the pierce? We'll call this the block for the pierce and make the entity real and add a backstop. Step number 1, entity hygiene. Boring, powerful, and non-negotiable. In other words, treat the LLC like a real business, separate bank accounts, clean bookkeeping, document distributions and loans, sign as manager, not as yourself personally. So John Smith, manager, not just John Smith when you sign contracts. Don't commingle ever. So that sounds annoying. Remember, your job is to be boringly credible. Step number 2, don't rely on a local judge as your final firewall. For high net worth, especially $1 million to $20 million plus with active exposure, domestic structures can be your first layer, not the last. And this is where international asset protection comes in, and I'll be very precise about how we do it. Important note, in our framework, we do not place U.S. LLCs inside offshore entities or offshore trusts as the core control point because U.S. entities remain under U.S. judicial control. Instead, we use tools like properly documented UCC-1 liens and other lawful creditor hardening strategies payable initially to an offshore LLC inside of an offshore trust. And we use equity stripping for U.S. real estate. Translation, you keep domestic compliance where it belongs, but you move the leverage point out of reach. And if needed, we get a third-party lender to purchase that UCC-1 lien or the real estate lien and put the proceeds from that in your offshore trust. Here's a cliffhanger. In the next chapter, I'm going to show you the trap that ruins late planners, the clawback, and the exact timeline mistake that make judges angry. And I'll show you how the Cook Island structure is designed around calm waters versus duress, so you keep control until you must not. Okay, now chapter 4, trap number 3, the clawback, fraudulent conveyance, voidable transactions. This is the trap that punishes panic. Fraudulent conveyance, often called fraudulent transfer or voidable transaction, means the court believes that you move the assets to hinder, delay, or defraud a creditor. So let's make it painfully clear. If you get sued on Monday and sell your house to your cousin on Tuesday for $10, you're basically writing the plaintiff's lawyer a love letter. Courts love badges of fraud. Transfer after threat of filing. Transfer to an insider. Transfer for less than fair value. You keep control after the transfer. Secrecy, rushing, unusual behavior. Composite case study, Anthony. Anthony owns rentals and a construction company. He ignores planning. A dispute turns into a lawsuit. He panics and retitles the property, moves cash, and starts cleaning up ownership in a week. The plaintiff's attorney doesn't just sue for underlying claim. They also add fraudulent transfer allegations. Now Anthony has the original case, a second war over transfers, higher legal fees, and a judge who thinks he's playing games. So how do you block the clawback? The block for the clawback, timing plus documentation plus calm waters planning. The honest truth is this: the best defense is planning before the threat arises. I've been doing this for 35 years in the asset protection field, and the one thing no lawyer can find is a fix for a client who waits until the building is on fire to shop for smoke alarms. But here's the nuance high net worth planning uses. You implement structure while calm. You document legitimate reasons and legitimate economics. You run the clock while nothing is happening. That's one reason offshore jurisdictions matter. They can have different limitation periods, different burdens of proof, and different enforcement rules. The point is not to cheat. The point is to build a structure designed to function under pressure. Okay, now this brings us to the nuclear option, and I'm going to explain it in plain English. Chapter 5, the nuclear option, the Cook Islands Trust done correctly. Now, people hear Cook Islands Trust, and they imagine it's either magic or shady. Neither is true when done correctly. A Cook Islands Asset Protection Trust is a legal structure in a jurisdiction whose statutes are designed to protect trust assets from foreign judgments and foreign creditors under their rules and in their course. And yes, Asset Protection Planners, my company, has established more Cook Islands trusts, I believe, than any firm in the world. So I know what I'm talking about. I've personally been setting them up for about 30 years. So that matters because most mistakes in offshore planning come from people copying internet diagrams instead of building a real system. So let's address the 3 big misconceptions. Misconception number 1, a U.S. judgment automatically grabs offshore assets. No, typically a foreign creditor has to bring a new action locally, that is in the offshore jurisdiction, under local procedure with local counsel. They have to hire attorneys there, in other words. So that alone changes the incentives. Misconception number 2, you lose control of your own money. Well, not if it's structured the right way. Misconception number 3, it's only for billionaires. So you're in the $1 million to $20 million range with real exposure. You often look collectible. Now, here's the structure you asked for. Calm waters versus lawsuit. The structure is trust plus Cook Islands LLC, Calm Waters Management. So step number 1, we established the Cook Islands Trust. We have a lot of videos on this topic. Number 2, the trust owns a Cook Islands LLC. So the LLC is 100% owned by the trust or the appropriate LLC, depending on the plan design. Sometimes we've set them up in Nevis in the past, Nevis in the Caribbean. Okay, step number 3, when the waters are calm, you are the manager of the LLC. Practically, you direct lawful activity, investment accounts, decisions consistent with the trust deed in the plan. So here's the important part. Our trustee is a licensed, bonded trustee law firm. They're not your buddy. They're a professional fiduciary with legal obligations. That professionalism is part of why the structure holds up. Okay, now the duress switch. What happens when a lawsuit strikes? So when a lawsuit hits, U.S. courts try to force control through you. Bring it back. Turn it over. Sign this. In a properly drafted Cook Islands structure, the trust deed and the LLC operating agreement are designed for that duress, meaning you're being legally coerced. Control can shift away from you, not forever, not for fun, but for protection. So when a judge orders you to repatriate or bring back the assets and you no longer have legal authority to do so, you can truthfully say, Your Honor, I don't have the power. It's not a loophole. That's designed. And when the pressure ends, the threat can pass. Control can return because you were never trying to abandon your assets. You're trying to keep them from being used as settlement hostages. Cliffhanger. In the next 3 minutes, I'm going to give you a simple 3-step anti-trap checklist that you can implement this week. No jargon, that will immediately reduce your worth suing profile. Okay, Chapter 6, the anti-trap checklist. 3 moves to block their 3 moves. So let's line this up cleanly. If they try to map your assets, trap number 1, you block it with privacy and compartmentalization. So don't keep everything in personal name. Separate buckets. Use privacy tools where appropriate so a casual search doesn't equal a complete asset list. For example, we use land trusts to own real estate. So you have privacy of ownership. The title isn't just in your name or one LLC that holds a bunch of properties. So we separate ownership through privacy tools like land trusts, for example, plus LLCs as the beneficiaries of those land trusts. Next, document discipline. Be mindful of what you sign and store. Don't casually create the paperwork that becomes a pre-built roadmap for discovery. If they try to freeze and pressure, trap number 1, second phase, you block it with equity management for exposed real estate. Reduce visible free equity where appropriate with legitimate recorded liens and clean planning. Cash flow separation. So don't let payroll and wealth sit in the same puddle. Now, if they try to pierce, trap number 2, you can block it with entity hygiene, separate accounts, records, documented distributions. Layered architecture. Don't rely on LLC alone as your end game if your exposure is real. If they try to claw back, trap number 3, you block it with timing. Plan while calm and legitimacy. Document business purpose, fair economics, normal behavior. Okay, now one quick natural invitation, early, not salesy. If you want more videos like this that explain the real legal playbook without turning it into a 3-hour law school lecture, go ahead and subscribe right now. Check to see if you're subscribed. If you're not, please do, so we can see each other again and I can provide more valuable information to you. And one soft resource mention, if you want to learn the architecture and see educational materials, you can start by visiting us at assetprotectionplanners.com. Even if you never hire anyone, understanding the framework helps you avoid expensive DIY mistakes. And if you like, you can fill out a free consultation form if you're serious and not curious, and you have $500,000 or more of equity, and talk to one of our attorneys or consultants. Okay, Chapter 7, the real goal, become annoying to collect. Here's the mindset wealthy families adopt that changes everything. They don't aim to be unsuable. They aim to be uncollectible enough that lawsuits lose their profit motive. Plaintiffs' attorneys, especially contingency counsel, make rational decisions. How hard is it to find assets? How hard is it to trap them? How likely is collection? How long will it take? What will it cost? Your job is to make those answers ugly. And you do that by lowering free visible equity, separating cash flow, maintaining real entities, planning early, and using high-level structures when your exposure and net worth justify it. Okay, in closing, calm, confident, and practical. Let's recap the 3 traps. First, the freeze, prejudgment pressure like attachment and Liz pendens to trap liquidity. The pierce, attacking your LLC as alter ego plus reverse piercing risk. Next, the clawback, fraudulent transfer claims when you move assets too late. And the 3 roadblocks, structure that reduces leverage, discipline that makes your entities real, timing that keeps your plan credible. If you built real wealth, you already understand one principle: you don't get rewarded for being naive. You get rewarded for being prepared. I'm the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. I've spent 35 years in this field and 30 years building Cook Islands trust plans for clients who refuse to let a lawsuit become a financial hostage situation. So thanks for watching, and I'll see you in the next one.